Hi there, this is Jonathan Ginsberg. I'm an Atlanta area Social Security disability attorney, and today I'd like to answer the question, why do disability judges use vocational witnesses at your Atlanta area Social Security disability hearing? And if you've never been to a hearing, what happens there is that these are fairly informal. They last about 45 minutes to an hour. But when you get into your hearing, you're going to see, besides the judge and me, if I'm your attorney, and a hearing reporter that works for the judge, there's going to be a fifth person in this hearing. This is a vocational witness, and in the Atlanta hearing offices, Atlanta North, or Covington, 99% of the time they're going to be vocational witnesses. And vocational witnesses are people you've never met before. They're folks that have never seen you before, never done any examination of you before. But they're there to help the judge understand the vocational or work activity limitations of your medical condition. And so what happens is the vocational witness will sit through the hearing, listen to testimony, and then after the testimony is given, the judge will turn to the vocational witness and pose one or more hypothetical questions. Mr. Vocational Witness, assume an individual the same age, education, and work experience as our claimant. Assume further, I find that this hypothetical individual is limited to light work. And light work, by the way, is defined very specifically as being able to sit for up to 6 hours in a day, stand for up to 6 hours in a day, lift, I think it's 10 pounds frequently, 20 pounds occasionally. There's a very specific definition, but limited to light work with the following limitations. This individual should avoid ladders, ropes, and scaffolds. This individual should avoid working in unprotected heights or around hazardous equipment, around vibration equipment. This individual should avoid extremes of temperature. This individual should limit overhead reaching with the dominant hand to occasional. This individual should limit change in the work setting to frequently. This individual should limit foot controls to seldom, and any variety of things that relate to your particular case. And the vocational witness will then identify various jobs that you could or could not do given those limitations. So question one would be, could our hypothetical person return to the claimant's past work? No, because the claimant's past work required use of foot controls, and your hypothetical made foot controls only occasional, and the past work was on a frequent basis. Are there any other jobs such a person can do? Yes, this person could be a foil wrapper, a hand packer, a surveillance system monitor, a cashier, any number of type of things. And the judge will then go through any number of hypotheticals. It could be one, it could be 10, to keep asking the vocational witness to eventually get to the point where the vocational witness says there are no jobs this person could do. For our purposes, the sooner we get there, the better. We want the judge to associate your limitations and your testimony and the evidence in your file to a hypothetical question that yields the result of no jobs. Now, it can be very difficult to tell because some judges will ask 5 questions, the last one will be no jobs, and that's the one the judge will adopt as his or her analysis of your situation. Other judges ask only 2 or 3 questions, and it's very obvious from the question they ask that they've decided that your limitations are quite severe and that you would not be able to do any work. I'm allowed as your attorney to ask questions as well, and sometimes the judges will adopt my question as a representative or as a representation of your functioning. But at the end of the day, we want the judge to get to the point where the vocational witness says there are no jobs that I can identify based on the limitations set forth in your hypothetical question. That is what the vocational witness is there to do, not to help you or hurt you, but to help the judge understand the vocational limitations, the work limitations of your particular medical issue. And we want the answer from the vocational witness to be, Your Honor, I cannot identify any jobs this person can do. Now, a couple other things to know. The vocational witness will use a book, reference a book called the Dictionary of Occupational Titles. And that is an outdated book. It's a publication of the Department of Labor, has not been updated since the 1990s, but they still use it for some unknown reason. So a lot of times when the vocational witness is identifying jobs, they'll say, this is DOT number 783-432-101 or 010. This is a light semi-skilled type of job. So they use that to determine what the jobs might be. And now they're going to some other resources, but that's the typical one they use. So if you hear that, that's what that is, the Dictionary of Occupational Titles, or the DOT. That's simply just a book. It's online. You can look at it up if you want to, of jobs that exist and what the requirements for those jobs are. So obviously, if the DOT says this job requires medium level lifting, where you're lifting 25 pounds frequently and 50 pounds on occasion, then if your limitation is 10 pounds on occasion, then you would not be able to do a medium job per the DOT and the vocational witness's testimony. So that's kind of what it's used for in that regard. The second thing is there's been some proposals by Social Security to limit the vocational witness's participation in the hearing, where they will only come into the hearing after the testimony is given. In fact, there's even some thought about making vocational witnesses remote witnesses, where they don't even appear in person. They're just listening over the phone, or they come in over the phone when the judge is ready to ask questions, so they're not influenced at all by your testimony. I think it's a terrible idea, because if they're on the phone, we don't know what they're doing. They could be painting their toenails, or they could be, paying their bills on QuickBooks or something. We don't know if they're listening at all. And I think that it really helps my clients, certainly, to have a vocational witness observe them, because that's part of the vocational witness's expertise, is to observe what's going on with the claimant, to read the nonverbal cues as well. But we don't know what's going to happen. Right now, most of the time the vocational witnesses are present. Sometimes they're appearing by phone. Right now they're there for the entire hearing. That could change, but as I'm recording this in the middle of 2018, vocational witnesses are still participating in the full hearing. So that's what the vocational witness does. That's who he or she is. There are a panel of them. Most hearing offices, and certainly the ones in Atlanta, there's a panel of them at maybe 25 or 30, so we typically see the same ones over and over. And they're, again, not there to hurt you or help you. They're there to help the judge understand the work implications of your medical issues. And the final point is, even though the vocational witness is the expert, a judge who's done this for 10 years knows what the vocational witness is going to say. So the questions that the judge asks are not going to give an unknown answer. The judge knows that if he puts in, for example, this person would be absent 3 or more days of work a month, every vocational witness is going to say there are no jobs. If the judge puts in this person would be off task for 3% of the time, that's the only limitation, the judge knows the vocational witness is going to say that's not going to stop this person from working. So it's somewhat of a shell game in that the judges know what the vocational witnesses are going to say. Every once in a while you get a situation where the judge gets surprised, but it's more or less a form over substance type of thing. But we still go through the exercise, and I've had a couple of cases where I was able to bring out a few things in testimony that the vocational witness, the judge did add to the question, or that my question the judge did adopt, and we were able to win on that basis. So it's certainly a relevant exercise, but it is somewhat of a way for the judge to confirm his or her own decision based on the review of the evidence and listening to testimony. That's who the vocational witness is. That's what the vocational witness does. So sometimes it's called the VE, the vocational expert, but that's who that person is that you've never seen before when you get to your hearing. Hope you found this helpful. If you have any questions, please leave me a comment at my website, or at my YouTube channel, or at the Facebook page. Subscribe to my YouTube channel, like our Facebook page. Visit my website, ssdanswers.com /Atlanta. You can download my Secrets to Winning Disability Survival Kit there. And if you have any questions for me, 770-393-4985. Again, I'm Jonathan Ginsberg here in Atlanta, wishing you all the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.